The planned invasion of Greenland is off. Probably. Maybe. I don't know. We still have the plans, just in case.
All my testimony is that the Pentagon has plans for any number of contingencies.
Instead, hundreds of Marines and several thousand soldiers with the California National Guard deployed to Los Angeles. Devin's already covered the legal questions about the deployments themselves. One issue that has repeatedly come up, though, is just what orders do the soldiers and Marines have to follow? If the orders seem illegal, say, arrest civilians or open fire on protesters, can't they just disobey them? The answers are complex and may surprise you. One of the first formal things a person does when they join the military is swear an oath. It's more than ceremonial. It has legal effect. Think of it like a witness in a courtroom swearing to tell the truth, the whole truth, and nothing but the truth. If the witness does that and then provably lies during their testimony, they can be prosecuted for perjury because of that oath. The oath that enlisted service members use is contained in a statute, 10 U.S.C. section 502. I, state your name, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, and that I will obey the orders of the President of the United States and the orders of the officers appointed over me according to regulations and the Uniform Code of Military Justice. Commissioned officers have a different oath of office contained in a different statute, 5 U.S.C. section 3331. This is the oath I took when I became a commissioned officer in the Marine Corps. The officer's oath does not explicitly talk about obedience to orders, instead requiring the officer to swear to well and faithfully discharge the duties of the office on which I'm about to enter. Obedience to orders is then included as one of the officer's duties in the commission itself. This officer is to observe and follow orders and directions as may be given by the President of the United States or other superior officers acting in accordance with the laws of the United States of America. The oaths and commissions for the National Guard are basically identical except that they add references to state constitutions and governors. All of these oaths explicitly or implicitly acknowledge that orders must be issued in accordance with the Uniform Code of Military Justice, among other laws and regulations. The Uniform Code of Military Justice, or UCMJ, is the bedrock of the military justice system. Passed into law in 1950, it codified and made uniform a system of justice across the U.S. Armed Forces. Among other things, it lays out crimes, punishments, procedure, and rules of evidence. Since we're talking about service members potentially disobeying orders, let's get right to the meat and potatoes. There are two major UCMJ articles that deal with this. Article 90, willfully disobeying a lawful command of that person's superior commissioned officer, and Article 91, willfully disobeying the lawful order of a warrant officer, non-commissioned officer, or petty officer. Now, these articles are no joke. Violation of Article 91 can carry up to 1 or 2 years of confinement, depending on who's giving the order. Violation of Article 90 can carry up to 5 years of confinement during peacetime and up to the death penalty in wartime. I will say that again. Willfully disobeying a lawful command of a superior commissioned officer during wartime can be punished with the death penalty. Remember Maverick? Now, is that a likely sentence? No. But if a superior commissioned officer ordered you to keep the streets clean, and you knew that throwing your gum on the sidewalk could be punished with the death penalty, even if it were really unlikely, you would probably think hard before tossing it. Also, just don't litter. For our purposes, the focus is on the word lawful. The obligation to obey orders and the punishment for disobeying orders is conditioned on those orders being lawful. So what is a lawful order? Well, let me just give you some black letter law. Orders from superiors requiring the performance of military duties are presumed to be lawful. The dictates of a person's conscience, religion, or personal philosophy cannot excuse disobedience. An order is disobeyed at the peril of the subordinate. And in most cases, the service member doesn't get time to sit down and do research about the lawfulness of an order. Immediate compliance is required for any order that does not explicitly or implicitly indicate that delayed compliance is authorized or directed. You don't get to file a grievance with a union. And if you think the federal courts will have a different opinion, well, here's the U.S. Supreme Court's opinion. An army is not a deliberative body. It is the executive arm. Its law is that of obedience. No question can be left open as to the right to command in the officer or the duty of obedience in the soldier. That seems pretty strict. It is. And the thing about disobedience being at the peril of the subordinate is really important. The legality of an order is not an element of the disobedience offense. It is a question of law to be determined by a military judge. So if a service member disobeys an order because they think it's unlawful, they could suffer all of the difficulties of a court-martial, including pretrial confinement and the stress of the unknown, just to finally, somewhere down the road, have a military judge rule that the order was in fact unlawful. It's a whole lot easier to acknowledge, salute, and execute. And it's designed that way.
We're here to preserve democracy, not to practice it.
Punishing disobedience is part of how obedience to orders is incentivized in the military. It's also just part of military culture. Instant obedience to orders is drilled into recruits and officers from day one. Another incentive is that obedience to orders is a legal defense in a criminal prosecution. An act performed pursuant to a lawful order is justified. It is a defense to any offense that the accused was acting pursuant to orders unless the accused knew the orders to be unlawful, or a person of ordinary sense and understanding would have known the orders to be unlawful. Another way of putting that last clause is that the inference of lawfulness that we previously talked about does not apply to a patently illegal order, such as one that directs the commission of a crime. This is the legal mechanism for how killing in war is ordinarily not criminal homicide. Criminal homicide is the unjustified killing of another person. Following lawful orders is justification. So killing in war, under most scenarios, is justified killing. There's a common saying, lawful but awful. But wait a second, isn't this the Nuremberg defense? The defense that high-ranking Nazis tried to use to defend their actions during World War II? That they were just following orders? And wasn't that rejected? Well, kind of, but not really. One of the legal rules that was applied to the Nuremberg trials was Nuremberg Principle 4, which read, "The fact that a person acted pursuant to order of his government or of a superior does not relieve him from responsibility under international law, provided a moral choice was in fact possible to him." The fact that a person was following orders was seen as potential mitigation of punishment, not a defense to allegations of war crimes. But the reason for Nuremberg Principle 4 and the rejection of the legal defense of superior orders was because the Allies had already determined that the actions commanded by the orders were patently illegal, executing prisoners of war, genocide, etc. If the orders were patently illegal, there is no defense. So it actually wasn't a substantial deviation from current US and international law. For example, the 1998 Rome Statute, which is the foundational document for the International Criminal Court, spells out the current rule in Article 33. The fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of a government or of a superior, whether military or civilian, shall not relieve that person of criminal responsibility unless A, the person was under a legal obligation to obey orders of the government or the superior in question, B, the person did not know that the order was unlawful, and C, the order was not manifestly unlawful. The article continues, "For the purposes of this article, orders to commit genocide or crimes against humanity are manifestly unlawful." This tracks pretty closely with the superior orders defense as outlined in the Uniform Code of Military Justice, basically just substituting manifestly for patently illegal. Let me give a historical illustration for the US military. US Army 2nd Lieutenant William Calley and the My Lai Massacre. Calley led a platoon in Company C, 1st Battalion, 20th Infantry Regiment. On March 16, 1968, right after the Tet Offensive, Company C assaulted a village called Son My in South Vietnam. The suspicion was that the remnants of the Viet Cong's 48th Battalion were taking refuge there. Calley's platoon entered the hamlet of Tu Cong, which had erroneously been marked on army maps as My Lai, and proceeded to massacre hundreds of civilians, including children and the elderly. This included pushing these civilians into a ditch and shooting them. Mothers jumped on the bodies of children to protect them, only to have the children who could walk mowed down as they fled. Calley was later court-martialed for numerous counts of murder. He had two defenses. First, that the massacre was actually the result of an unintentional airstrike. That did not go well for him. Calley's second defense was that he was just following the orders of Company C's commanding officer, Captain Ernest Medina, and I'm being serious here, that Calley was just too dim-witted to perceive the alleged orders as patently illegal. There is some dispute over what Captain Medina did and didn't order, but ultimately that didn't matter. Calley was convicted of 22 counts of murder. In upholding the verdict, the Court of Military Appeals said the following: whether Lieutenant Calley was the most ignorant person in the United States Army in Vietnam, or the most intelligent, he must be presumed to know that he could not kill the people involved here. In order to kill infants and unarmed civilians who were so demonstrably incapable of resistance to the armed might of a military force as were those killed by Lieutenant Calley is palpably illegal.
Now, sorry to interrupt, but if you get court-martialed, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
So what happens if a service member obeys a patently illegal order? Well, not only do they lose the obedience to order's defense, to whatever it is the patently illegal order commanded them to do, but they may commit the additional crime of dereliction of duty. Article 92 of the UCMJ makes it a crime when a person willfully or negligently fails to perform that person's duties. Dereliction of duty is a very broad provision, but in this context, the duty to disobey an unlawful order applies only to a positive act that constitutes a crime that is so manifestly beyond the legal power or discretion of the commander as to admit of no rational doubt of their unlawfulness. So this is the framework we have. If a service member obeys a lawful order, or at least one that isn't patently illegal, they do not commit a crime. If a service member disobeys an order thinking it's unlawful, they do so at their own peril. And if a service member obeys a patently illegal order, they not only lose the obedience to order's defense for whatever they did, but they may also commit the separate crime of dereliction of duty. It's easy to see the black and white unlawfulness of obeying an order to commit genocide, for example. But for most things, it is a whole world of gray. Ken White, a smart and funny lawyer and podcaster, posted this on social media. America's military, including the National Guard, can and should refuse unconstitutional orders. May those men and women who fight for the lawless regime face appropriate consequences. Now, I single Ken out not because he's especially wrong or even wrong-headed, but because this is one of those issues that sounds easier than it really is. Let's assume a service member wants to disobey an order because he thinks it's unconstitutional. He has to overcome the presumption of lawfulness. The way to do that is to show that the order is patently unlawful, which is to say that it commands a positive act that constitutes a crime that is so manifestly beyond the legal power or discretion of the commander as to admit of no rational doubt of their unlawfulness. No rational doubt. Can you expect a 19-year-old enlistee to have an interpretation of the United States Constitution that objectively offers no rational doubt? 23-year-old lieutenant? I think the answer to that is no, almost never. Now, I get it. The oaths service members give include to support and defend the Constitution of the United States against all enemies, foreign or domestic. Well, that sounds to some like it could be a get-out-of-jail-free card to avoid apparent unconstitutional orders. I think Professor Oren Kerr gets it right. The oath is probably best understood in its historical context as a promise to oppose political reforms outside the Constitution. You have to stay loyal to the government that is based on the Constitution, and you can't support a rebellion or overthrow of that government. In other words, the oath to support and defend the Constitution is not an invitation for millions of uniformed American service members to independently enforce their own view of the Constitution. It also doesn't empower the military to supersede civilian orders under the military's own interpretation of the Constitution. That's how we get from General Mark Milley, chairman of the Joint Chiefs of Staff during Trump's first term, to General Mark Milley, chairman of the Glorious People's Revolutionary Council. And no one wants that. But maybe Ken or someone else thinks that it's the deployment orders themselves that are unconstitutional. Not the orders to protect and assist ICE agents in Los Angeles, but the mobilization order to enter active duty and go to LA. Or let's go a step further, how about orders to invade Greenland? If the commander-in-chief orders a deployment that subordinates in the military believe to be unlawful, can they refuse to go? This kind of thing actually has been litigated before, many times. In 1990, Captain Yolanda Huet-Von, a doctor in the Army Reserve, resisted deployment orders in support of Operation Desert Storm. The Court of Appeals for the Armed Forces upheld her conviction for desertion, holding that the legality of the decision to employ military forces in the Persian Gulf pertained to a non-justiciable political question. In other words, Huet-Von's order to deploy to the Persian Gulf could not be reviewed by a court for lawfulness, because the order falls under the war powers vested by law to the political branches, Congress and the President. Similar findings were made when First Lieutenant Aaron Watada refused to deploy to Iraq in 2009, and when Captain Nathan Michael Smith sued the Obama administration, alleging that Operation Inherent Resolve, also in Iraq, was illegal because Congress did not authorize it. Okay, well, What if the service member who was just called up decides to quit or resign? Because by golly, my heart's just not into it. Well, that's not an option either. You can't just resign or quit when you have a multi-year contract or obligation, which virtually all service members have. Moreover, an officer's request to resign can be denied, which happened with First Lieutenant Watada. The fact is, there's very little room for disobedience in the military, from the greenest boot E1 to the saltiest 4-star general. It is the dominant feature of civil-military relations in the United States, especially in the post-World War II era. It means that the military can be deployed in unpopular or even potentially illegal ways. According to DHS Secretary Kristi Noem, Marines and soldiers from the California National Guard will apparently be assisting ICE agents to liberate Los Angeles from its socialist, burdensome elected leadership. But obedience to orders means that the solution is left to the political branches, not the military. Gosh, it seems like service members would have an awfully hard time avoiding orders, no matter how distasteful those orders are to individual service members. Yes, that's correct. But let's say, hypothetically, Lance Corporal Schmuckatelli decides that he isn't going to help ICE in Los Angeles. He sits on his bunk and says, "No, I won't do it. I refuse those orders." What happens next? Chances are good he will be court-martialed for willfully disobeying orders. That's just the natural next step. Charges will be referred against him, and some general will convene a court-martial. Conviction could result in reduction of rank, a punitive discharge where he loses most of his benefits, and probably serious time in confinement. But what if I told you that there might be this one weird trick to avoiding the worst consequences of disobedience? In the military justice system, there's something called unlawful command influence. Article 37 of the UCMJ makes it unlawful for a military commander to attempt to coerce or, by any unauthorized means, influence the actions of a court-martial or any member thereof. Unlawful command influence has often been referred to as the mortal enemy of military justice, so much so that even the mere appearance of unlawful command influence may be as devastating to the military justice system as the actual manipulation of any given trial. Unlawful command influence is so important because of the unique structure of courts-martial. Virtually all the key players in a court-martial, the lawyers, the judge, witnesses, members of the jury panel, are uniformed service members who could have both legal and professional reasons not to act against the wishes of those above them in the chain of command. If a commanding officer or anyone in the chain of command tries to influence the court-martial, what would you expect to happen? We've been talking about how obedience to orders is central to the military's soul, right? When a military judge finds unlawful command influence, the consequences can range from changing where the trial happens, to limiting the sentencing options if the accused is found guilty, to outright dismissal of the charges. In 2013, in light of a recent report showing a rise in reported sexual assault in the military, President Obama made some public comments that to the untrained eye might seem fairly banal. But after President Obama called for a specific outcome in sexual assault cases, dishonorable discharge, period.
If we find out somebody's engaging in this stuff, they got to be held accountable, prosecuted, stripped of their positions, court-martialed, fired, dishonorably discharged. Period.
A military judge in Hawaii found unlawful command influence in 2 pending sexual assault trials. The judge ordered that even if the accused in those trials were found guilty, they could not receive punitive discharges, like dishonorable discharge, as part of their sentences. Did President Obama reference those 2 cases at all? No. But that's how seriously unlawful command influence is taken in the military justice system. Back to Lance Corporal Schmuckatelli, refusing to obey orders to help ICE in Los Angeles. Does anyone think this administration, from President Trump on down, has the discipline not to make public comments about it? About how Lance Corporal Schmuckatelli needs to be executed for treason? Look at Trump's comments about Bo Bergdahl.
Now, in the old days, with Bergdahl, who was a traitor, it was treason. You shoot him, he gets shot.
They wouldn't be able to keep their mouths shut. The problem with all this is that it's well into the find out part of fuck around and find out. You can't tell Lance Corporal Schmuckatelli that it'll all work out in the end because Trump administration goons can't control their social media freakouts, and a military judge will ultimately dismiss the case for unlawful command influence somewhere down the line. That is an untenable strategy for success. If he chooses to disobey orders, no matter how immoral or illegal he thinks they are, he does so at his own peril. So maybe Lance Corporal Schmuckatelli should call the GI rights hotline at 1-877-447-4487 or visit girightshotline.org.
And maybe Lance Corporal Schmuckatelli should also remove as much online personal data as he can, which he can do with the help of today's sponsor, Incogni. Now, in case you're not familiar with these data brokers, these are the companies that vacuum up your personal data from all corners of the internet and sell it to anyone who wants to buy it. But Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. Incogni also just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really great. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. And these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. And it might also be why you're getting so many spam calls lately or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. And I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take literally weeks. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the data broker removes your data once, they can collect it again. So Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get an exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click on this link over here for more LegalEagle, or I'll see you in court.